The American people deserve to have an answer in the courts before the upcoming election. Now, because of today's decision, that is highly, highly unlikely. Today's Supreme Court decision, once again, it will depend on the character of the men and women who hold that presidency, because the law will no longer do it. Any president, including Donald Trump, will now be free to ignore the law.
Debate on executive power. The U.S. Supreme Court has granted former President Donald Trump immunity, ensuring that his criminal trial for trying to overturn the 2020 presidential election will not go to trial before the 2024 election in November. The decision grants presidents in general absolute immunity from prosecution for core official acts, and said that presidents should be presumed immune for a much more expansive list of acts. The majority opinion, composed of 6 conservative justices, believes that the decision does not place presidents in general, and Trump in particular, above the law. However, 3 liberals dissented with a warning about how elevating a president will affect American democracy. The near-term result of delaying Trump's trial while a court in Washington, D.C. considers which criminal activity that Trump is accused of can be considered unofficial and has a long-term effect of placing presidents in a different system of justice than other Americans. Chief Justice John Roberts explains the new immunity as including absolute immunity from some actions and a presumption of immunity for others. The court concludes that under the constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. A president gets at least a presumptive immunity, even for acts within the outer perimeter of his official responsibility, but it is careful to add that he gets no immunity for unofficial acts. The court argues that presidents are still accountable, and not everything the president does is official. During oral arguments in the case, Trump's attorney John Sauer told Justice Amy Coney Barrett that multiple elements of the indictment would indeed be private or unofficial acts. The majority takes no position and wants the trial court to go through the allegations individually. The majority gives quite a bit of detail about what might be official or not, such as Trump having absolute immunity for any instructions or pressure he exerted on his acting attorney general. The court won't allow as evidence any interviews with people who worked in the administration and won't let a court consider a president's motives for taking an action. The Supreme Court has embraced Trump's theory of immunity, guaranteeing that the trial will not happen before the election. Trump asserts a far broader immunity than the limited one we have recognized, arguing that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. The court dismisses warnings about a president operating above the laws as fear-mongering on the basis of extreme hypotheticals. It is more important to protect the president from political prosecutions, as the Constitution vests in him sweeping powers and duties. The dissents overlook the more likely prospect of an executive branch cannibalizing itself, with each successive president free to prosecute his predecessors, yet unable to boldly and fearlessly carry out his duties for fear that he may be next. The court's considerations are more far-reaching than what is happening at the moment. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer, but in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. The majority did not weigh in on the brewing argument among conservatives that Smith should not even have a job and that his role as a special counsel is unconstitutional. Justice Clarence Thomas endorsed the idea in a concurring opinion. In this case, there has been much discussion about ensuring that a president is not above the law.
The Supreme Court has just issued a ruling involving hundreds of people convicted for their actions under a 2002 financial crimes law applying to evidence tampering.
This is a potential win for this defendant from the Capitol on January 6th and was charged with this obstruction of an official proceeding.
Justices weighing whether to reverse the convictions of hundreds of January 6 rioters charged with obstruction. The case brought by Joseph Fisher, who entered the Capitol on January 6 and was charged with obstruction.
Trump's hush money case. A New York judge has postponed Donald Trump's sentencing until September, providing his legal team additional time to challenge his conviction following a landmark Supreme Court ruling. Initially set for July 11th, Trump's sentencing is now on hold as his lawyers seek to overturn his conviction in a hush money case, citing the Supreme Court's decision on presidential immunity. Justice Juan Merchan, overseeing the case, announced on Tuesday that he would rule on the motions by September 6th. If sentencing remains necessary, it will take place on September 18th. This development comes after a New York jury in May found Trump guilty of 34 felony counts of falsifying business records, marking the first time a former U.S. president has been convicted of a felony. Prosecutors argued that Trump reimbursed his former fixer, Michael Cohen, for hush money paid to adult film star Stormy Daniels, covering it up by falsely labeling it as legal expenses. The payment, made just before the 2016 election, aimed to silence Daniels about an alleged affair with Trump. This hush money case is the first of Trump's 4 criminal cases to reach trial. Following Justice Merchan's ruling, Trump took to his social media platform, Truth Social, to declare the delay as total exoneration and claim it ends the witch hunts against me. However, this decision merely pauses the proceedings until the judge makes a final determination.
He studied very hard. He studied so hard that he didn't know what the hell he was doing. He got the network that he wanted. No amount of rest or rigging could help him defend his atrocious record.
On Monday, the Supreme Court delivered a bombshell ruling asserting that Trump and other former presidents possess immunity from prosecution for official acts conducted during their tenure. This ruling emerged from a federal criminal case accusing Trump of attempting to overturn the 2020 election results, but has implications that could extend to his other legal battles. Trump's legal team quickly moved to leverage this ruling in the New York case, aiming to overturn the May conviction by arguing that some of the events and evidence central to the case occurred while Trump was president. The Manhattan District Attorney's Office, which prosecuted Trump, dismissed his argument as without merit, but requested until July 24th to file a formal response. Legal experts, however, predict an uphill battle for Trump in this context. The allegations in the New York fraud case in which Trump was convicted seem clearly to relate to unofficial conduct by Trump, none of which would seem to involve his official duties, noted Mark Zotterer, an appellate attorney in New York. While Trump will be able to litigate his immunity defense in some of his cases, he will have a most difficult time succeeding with this argument in the New York case. The case's core revolves around Cohen's payment of $130,000 to Daniels for her silence regarding an alleged 2006 physical encounter with Trump, and Trump's subsequent reimbursement of Cohen through falsely labeled legal expenses. These actions, occurring when Trump was a presidential candidate and then president, are pivotal to the prosecution's argument that they were not official presidential acts. Philip Bobbitt echoed this skepticism. "I just don't see it," he told the BBC, referring to the difficulty in convincing a court that such behavior constitutes official presidential acts. This legal drama unfolds against the backdrop of Trump's broader legal woes. His lawyers aim to exploit the Supreme Court's ruling to challenge his convictions and delay proceedings, especially critical as Trump campaigns for the 2024 presidential race. The Supreme Court's decision has already delayed Trump's trial related to attempts to overturn the 2020 election, ensuring it will not proceed before the upcoming presidential election. Justice Clarence Thomas, in a concurring opinion, endorsed the idea that the role of a special counsel, like Jack Smith, might be unconstitutional, reflecting the ongoing conservative debate about the scope and limits of presidential immunity. The Supreme Court's ruling emphasizes the importance of protecting a president from politically motivated prosecutions, arguing that the Constitution grants sweeping powers and duties to the president that necessitate some level of immunity. The majority opinion dismisses warnings about presidents operating above the law as fear-mongering on the basis of extreme hypotheticals.
I want to ask you about January 6, 2021. After you rallied your supporters that day,
3 hours watching, being begged by his vice president to do something, to call for a stop, to end it.
What happened to the United States' reputation is horrible. We had a big victory against a man that really is looking to destroy our country. He's the worst. He's the most corrupt. He studied very hard. He studied so hard that he didn't know what the hell he was doing.
Fears of authoritarianism. The Supreme Court has granted total immunity to former U.S. President Donald Trump from criminal prosecution linked to his time in office. The ruling, handed by Chief Justice John Roberts, exempts Trump from criminal prosecution for acts interpreted as part of his core duties and presumes immunity for all other official acts. This decision sets a worrying precedent for future abuses of power from U.S. presidents and underlines the level of unreliability, instability, and volatility of U.S. politics. Professor Inderjeet Parmar, a professor of international politics at City University of London, argues that the ruling gives the green light for a dictatorship in the U.S., undermining the Constitution and democratic norms of accountability. He suggests that the U.S. is unable to claim to be a beacon of democracy and an opponent of authoritarianism, and that the ruling may normalize authoritarianism worldwide. Biden could use the power to appoint more Supreme Court justices to balance out the conservative bench, similar to President Roosevelt's New Deal program in 1937. The ruling reverses the critique of an imperial presidency and paves the way for a potential dictatorship. This significant expansion of presidential power and a major setback for democratic accountability in the U.S. is a significant issue, as it shows that democratic backsliding is not limited to other parts of the world. That's all for this video, folks. See you next time.